show you the email. You can see it. You can see the email. Yeah, that's Leila. And it's not exact.
Thank you, everyone. Our final panel this afternoon is going to be on comparative perspectives in regards to many security and terrorism issues we discussed. Our moderator for the panel is going to be our own Professor Noah Weisbord, who has multiple degrees from the University of McGill in Canada, including psychology, social work, civil law, and common law, and is involved in the emerging international field of international justice, a broad range encompassing both international criminal law as well as transitional justice, a number of related fields, and has done Professor Weisbord has done extensive work in the Gacaca committees, which are community investigations into genocide complaints in Rwanda, a very interesting and controversial topic at times. And Professor Weisbord is currently a delegate to the Special Working Group on the Crime of Aggression established by the Assembly of States Parties of the ICC. Again, a very interesting and sometimes controversial topic. We are very grateful for his help moderating today, and without further ado.
Thanks a lot. Thanks very much for your kind introduction. It's my honor to introduce the final panel of the day. I'm hoping it's going to be a lively debate. This is on comparative perspectives on non-state actors and the law of armed conflict in the 20th century. We have a very interesting panel, a panel of international people of mystery, beginning with Michael Scharf, professor of law at Case Western Reserve and director of the Frederick Cox International Law Center. He's an alumni of Duke and a good friend, and will start us off with a discussion of his new book on the torture memos, Shaping Foreign Policy in Times of Crisis. We're fortunate to have Elies van Sliedregt, professor of criminal law and procedure at the Vrije University of Amsterdam, with us today from Holland. She's the author of a path-breaking book on the criminal responsibility of individuals for violations of international humanitarian law, along with a lot of other articles and analyses of the role of the individual in the system. Elies also serves as a deputy judge in the District Court of Amsterdam. My hope is that she will offer us some insights about the role of criminal law as a response to terrorism. Wrapping up our international panel of mystery is Jamie Williamson, a legal advisor to the International Committee of the Red Cross. This is the delegation responsible for visitations of U.S.-held prisoners from the Afghanistan and Iraq conflicts, as well as the ICRC's relations with the governments of the United States and of Canada. Jamie also has extensive experience in the field of international criminal justice. My hope is that Jamie will begin to address Madeline's question from this morning about what other countries are doing legally in response to threats by non-state actors. Michael, would you start us off?
Thank you very much, Noah. And I was happy to hear this is the 20th anniversary of the International Law Journal. Some of you may know that when I was a first year, along with Philip Nichols, who's now teaching at the Wharton School, we started the International Law Annual, which went for 4 years before it was transformed into this journal that's now one of the top international law journals in the world. Congratulations, you make Phil and I proud. This conference is about war bound by law, and that should probably be contrasted with the Latin phrase, silant enim lege inter arma, which most of you know, although I've mispronounced half of those words, means in times of war, the law must be silent. And one of the questions, if you're sitting out there and you're hearing these kinds of debates, you may be asking yourself, which better reflects reality in the context of the war on terror? The new book that Noah mentioned, Shaping Foreign Policy in Times of Crisis, seeks to answer that question. And it's really a response to Jack Goldsmith's book, The Limits of International Law, which argues that international law is not real law, it's just politics, and that it's no more illegal to violate the Geneva Conventions or customary international law than it would be for a business to violate a non-binding letter of credit. So a lot of people who've looked at this of Goldsmith's book have criticized it because the examples he uses through history are looked at through the outside, and he doesn't really know what the legal advice was on the inside and what the policymakers did. And they're all examples, mostly they're examples of times either that he could characterize as following the law out of convenience or not following the law. Paul Williams, my co-author, and I were attorney advisors at the State Department, and we had access to John Bellinger and 10 other former legal advisors. And so we brought them together under a grant from Carnegie into a room, and for 2 days we wrestled with the question, was international law perceived by you and the people in your office as real binding law? And secondly, were you able to convince the policymakers that it was real binding law? And third, what happened when they didn't follow your advice, if ever? And there were some surprising things that we learned. For example, most of the stories that are out there publicly are stories about things the United States has done. There's almost nothing ever been written about times when the US thought about doing something and their lawyers convinced them not to. So this book actually is chock full of those stories. It's also full of the stories where the lawyers convinced the US government to do something different in a different way or with a different legal justification in order to keep it within international law. Really surprising. And also in this book are stories of 4 times when the legal advisor's office was intentionally cut out of the decision-making on an international legal issue. One of those times, of course, was the situation involving the detainee treatment memos, the so-called torture memos. So that's what I'm going to be talking about today. And based on the Senate bipartisan report, interviews by Philippe Sand with the major characters in that story, the memoirs of John Yoo and Jack Goldsmith, and the discussions that we had with the former legal advisors, I'm going to try in the next 10 minutes to tell you how the United States got to the situation it got to in that case and what the lessons are. First of all, you have to start out with the fact that Vice President Cheney and the Secretary of Defense Rumsfeld agreed that in the war on terror, it was absolutely imperative to protect the United States by using methods of interrogation that would not normally have been allowed under the ordinary rules that the Defense Department was using or under the general interpretations of the Geneva Conventions and the Torture Convention. So what they start out with is hiring John Yoo. He's appointed deputy head of the Office of Legal Counsel, and they knew when they hired him that he was someone who had been writing on something called the plenary presidency, a very super powerful presidency in times of crisis, unbound by customary international law and able to avail himself of broad doctrines of necessity. So then they added to that the vice president's lawyer, David Addington. This is someone who, according to a number of interviews of people who worked on these issues at the time, it was said, if you favored international law, you were in danger of being called by Addington soft on terrorism. And he was a scary guy, and so people didn't just jump in front of him and yell about international law very often. Then you have to throw in Rumsfeld's lawyer, Jim Haynes, who is a civilian appointee. He's not one of the military lawyers who had worked their way up. And he was actually the best man at Addington's wedding, so they were kind of chummy. And then you top that off with the White House chief counsel, Alberto Gonzales, who famously characterized the Geneva Conventions as quaint and outmoded. According to Jack Goldsmith in his memoir, these 4 lawyers took to calling themselves, quote, the War Council, and literally became a little mini law firm unto themselves. And instead of the very broad, inclusive clearance process that I remembered from my time at the State Department, which ordinarily worked with having the legal advisor from state and the Justice Department people and the Pentagon people and the NSC and whoever else had a legal interest all weighing in on an issue. And if they couldn't agree on the right interpretation, it went to the NSC. And if the NSC couldn't broker a deal, then it went to the president, and the president got to know that when he made this decision that his lawyers from different branches had different opinions. That's the normal way. Well, these 4, according to Jack Goldsmith's book, called themselves the War Council and cut out the legal advisor's office, and they cut out a lot of other people. And they met frequently, and then they gave you the mandate of churning out memo after memo after memo, many of which are now public, some of which we still haven't seen. And they were then signed by John Yoo's boss, Bybee, who was the head of that office, but who confided that he deferred to Yoo's expertise in this area. So really, it was Yoo doing all this. Now, according to John Yoo, who has his own Kiss and Tell book, The War Council intentionally cut out the legal advisor's office from the memo writing and clearance process because, and this is a quote from the book, State and OLC often disagreed about international law. State believed that international law had a binding effect on the president, indeed on the United States, both internationally and domestically, whereas the War Council did not hold to that view. Okay, I wouldn't be able to assert these things if they didn't come out of the mouth of these people, because it is such an incredible story. Will Taft, who has a chapter in this book, and he was the legal advisor at the time, he states in the book, quote, L was likely excluded due to the fear that in light of some of the positions we had taken, that we would not agree with some of the conclusions that other lawyers in the Bush administration expected to reach, and that we might leak information about the work to the press. It's really fascinating. He's conceding the fact that the reason he was cut out is because the War Council were afraid that he might have a different position, and if his position didn't prevail, maybe they'd leak it to the press, and then the press would have seen these torture memos a couple of years earlier, and who knows what that would have done. When they learned of the approved interrogation methods, the legal heads of the several military branches then weighed into this situation. And they all opined with various language that's quoted in the book that the techniques, quote, cross the line of humane treatment. They arguably violate federal as well as international law, and they will expose our service members to possible prosecution. Now, Yu then writes what is known as the Golden Shield Memorandum, according to Jack Goldsmith. This is later codified by Congress and in the Detainee Treatment Act. And basically what it says is anybody who is implementing the legal opinions of OLC has immunity. First of all, it was a common law immunity under Yu's memo, and then later it became a legislatively declared immunity, which has not been tested in the courts. So what's the result? According to the December 2008 Senate Armed Service Committee report, this is before Obama's election. This is a close bipartisan committee unanimously deciding this, Republicans and Democrats all in agreement. Quote, senior officials in the U.S. government solicited information on how to use aggressive techniques. They redefined the law to create the appearance of their illegality. And then they authorized their use against detainees. The techniques were a direct cause of abuse at Gitmo, Bagram Air Force Base in Afghanistan, where the detainees are also being held in the hundreds, and Abu Ghraib. And this is called the migration theory. The final quote is, those OLC opinions distorted the meaning and intent of anti-torture laws, rationalized abuse of detainees, and influenced DOD and CIA procedures. So we don't have a court case on this, but I think that's as close as an objective opinion as you'll see. And I think pretty much everybody's agreeing at this point that the OLC opinions went too far. If we look at this as a snapshot in the year 2005, I think one would have to conclude that the United States in the war on terror didn't take international law very seriously, that the prevailing view was that international law had to give way to national security. In essence, Goldsmith and Yu had it right. But that wasn't the last word on this. The U.S. Supreme Court begins to weigh in. In 2004, you have the Rossell versus Bush case that said that Gitmo was not a law-free zone. 2006, in Hamdan versus Rumsfeld, the executive order establishing the military commissions was held to violate the UCMJ and the four Geneva Conventions, including in particular Common Article 3. In 2008, most recently, you have the Bamidian versus Bush case, which said that parts of the Military Commission Act were unconstitutional, the combatant status review tribunals were inadequate, and the 200, and most importantly, the 270 detainees at Guantanamo Bay have a habeas corpus right to challenge their detention in federal court. The majority says as follows in that case. The laws and Constitution are designed to survive and remain in force in extraordinary times. That is the exact opposite of the Latin phrase that I began with. And then in 2008, George Bush's appointee, who was a Republican and had been the chief counsel of the U.S. Court of Military Appeals, Susan Crawford, who's now convening authority at this time, she ends up dismissing all the charges against al-Qahtani, one of the high-level detainees that they had subjected to waterboarding. And she says, we tortured him. There is no debate. And that was why those charges were dismissed. Okay, now according to John Bellinger's contribution to this book, and I wish John was still here. I hope maybe he'll be popping back during Q&A. What happened because of these Supreme Court decisions is that this opened the door for L, the legal office in the State Department, to re-engage. And then the treatment of detainees became much more aligned with international law by the end of the Bush administration, before the Obama administration came in. And as he indicated, the Obama administration has not changed things very drastically from the last days of the Bush administration. So what's the lesson here? First of all, the Office of the Legal Advisor. Did I get this right so far? All right, so I've summoned the great man from the mount. So what's the lesson? The Office of the Legal Advisor that John headed is a really unique and important office within the government, and it needs to be at the table whenever issues of international law are being discussed and decided. There were 4 times discussed in this book in the last 30 years when L got cut out of the process, and according to the legal advisors, each was a train wreck, and then the Office of the Legal Advisor was asked to try to pick up the pieces. One was the mining of the Nicaragua harbor during the Sandinista regime. The second was the Iran-Contra arms for hostage deal. The third was the Alvarez-Machane kidnapping case, and then finally was this detainee treatment issue. Sir Frank Berman, who also participated in this process, he was the legal advisor from the United Kingdom for many years and thought of it as one of the deans of legal advisors throughout the world. He said that the last time a UK legal advisor had ever been cut out of the process like this was the 1956 Suez invasion, which he also thought was a terrible and utter disaster. But he said that after that, they had made an internal decision that they have followed scrupulously, that any decision that goes to the prime minister on foreign policy that has anything to do with international law has to have the considered opinion of their legal office. Now, that doesn't mean necessarily that they will follow that considered opinion. Most recently, in the case of Elizabeth Wilmhurst, the legal advisor, acting legal advisor from the UK during the 2003 episode leading up to the invasion of Iraq, she opined in a very detailed legal opinion that it would not be legal for the UK to join the United States and invade Iraq, and she just didn't agree with the legal analysis that had come out of the Bush administration, including by L at the State Department. The Prime Minister said, "Thank you very much. I've considered this. I find it very concerning, but I want another opinion." He got the Attorney General to write one. The Attorney General farmed it out or outsourced it to Christopher Greenwood. Chris is now the UK judge on the ICJ. That one said, Chris's opinion said, yes, it is legal, and more or less agreed with the analysis the United States had. But what's important, though, is even if the legal advice is not listened to, that it be heard. And that was what was missing in the case of the detainee issue. So what's unique about L? I mean, why can't we just let the OLC make all of our international law decisions? They're real good at making constitutional law interpretations. Let them do international law too. They're the best and the brightest, et cetera. Well, here's what's unique about L. First of all, L is confirmed by the Senate. Secondly, and interestingly, if you go into the Office of the Legal Advisor, all of the pictures of the former legal advisors are on the wall. It is a place, unlike many offices around the government, where they respect their long history, and they don't see themselves as just a political appointee doing the bidding of the president, but rather the custodian of a long history of upholding international law. There are 170 international law lawyers that are experts in international law. Many have been there for several years, some as long as 30 years. What this means is that they have greater expertise about international law than some of the other government lawyers. Not all of them. I mean, like Hayes Parks in the military, there's no one maybe that has as much expertise on the Geneva Conventions as him, but certainly the OLC people who popped in and did those decisions. They have a greater respect for the long-term policies that support the rule of law. They have more interaction with foreign counterparts than other lawyers throughout the government might have. They have more experience regarding the effect of reputational costs to this country and the concept of systemic reciprocity. So reciprocity is not just bilateral, as we heard this morning, but also there are concerns about systemic reciprocity. If we use a very novel legal justification for something, then not only will it be used against us, but other countries will use it against each other, and it will be like a ping pong ball or something that goes around the international system and ultimately lowers across the board the rule of law. So in sum, L is a very important and unique voice that needs to be heard, especially in times of crisis. And I believe, and I think John and Will Taft have written this in the book, that had they been at the table, the detainee treatment issue would have come out completely differently. Thank you.
Elies, would you like to lead us off?
I'd love to. Thank you very much. At the same time, also curious to hear the comments by John, but we'll have to wait a bit for that. Thank you very much for having me today. I will be speaking about European approaches to terrorism, and that means predominantly criminal law approaches, because the debate seems to be, at least in Europe, more about criminal law than the laws of war. And so I want to take you through some of the measures that have been adopted and the criticism that has been voiced as a result. Before that, before I start to go through those measures, I'd like to make two preliminary observations. Firstly, that while US authorities may have been heavily criticized by European partners because of their policies in Guantanamo and because of the military commissions, it's by now very clear that critique is also valid with regard to European law, European approaches to terrorism, and more particularly criminal law measures. And secondly, that to my mind, the whole debate about terrorism and the effect it has on criminal law should not be overstated, in the sense that I believe that there is a trend that's been there for a longer period of time, and that has to do with the fact that we live in what can be called a risk society, where banning risks is something to strive for, and terrorism and the threat of terrorism has increased that debate, has increased the need that politicians feel to ban risks. But rather than being a new development, it's something that is reinforcing existing developments. Right. Having said that, let's move on now to what I want to say today, and that's, first of all, I want to go through legislation of a few European countries. I selected those countries. I did an in-depth study that I won't I'll spare that today for you, but some of the results I will share with you. I chose those countries because some of them represent a common law system, other civil law systems, and like Germany, Italy, and the UK, countries with experience in fighting terrorism, domestic terrorism mainly, and a country like the Netherlands that is relatively new to it. I will also very briefly point out some of the measures that have been taken at EU level, and then mainly the blacklisting, freezing of assets, and the European arrest warrant, which is an extradition mechanism. I will discuss the combined effect of these measures on the criminal law principles underlying these systems, and I hope to conclude to make a few observations with regard to, or parallels I would like to draw on the IHL debate, the laws of war debate, and the criminal law debate when we discuss terrorism and the effect it has on law. Okay, if you study the legal systems that I just mentioned, you basically find 5 features, and I listed them on the slide. I'll go through them during the talk, but let me read them out. Preventive criminal law, that's the first development that you see when you study terrorism legislation post 9/11, basically, and it's referred to in the German term Vorfeldkriminalisierung, and it's basically criminalizing behavior in the very early stages before a terrorist attack or act has been committed. Secondly, the broadening of investigative powers. Thirdly, expanding pretrial detention. Fourthly, quasi-criminal law measures, measures that are not, formally speaking, criminal law of criminal law nature, but have a punitive effect. And then lastly, special evidentiary measures. Let's start with the preventive criminal law. Membership of a terrorist organization has been a crime in Germany, Italy, the UK for quite a while, before 9/11 already. And it is preventive criminal justice in the sense that it's an offense to be a member of an organization that has terrorist aims. You do not necessarily have to commit a crime as such, as long as it can be shown that you are actively supporting that organization. That's the offense. It's been extended post 9/11 to international terrorism. So those acts have been expanded in that sense. But the more important development has been the framework decision developed within the framework of the European Union and implemented at state level, where 3 new offenses were created: public provocation, basically preaching in public spaces to get people to join the terrorist cause, recruitment, more specifically for jihad purposes, and training for jihad purposes. Implementation of these offenses are different in the sense that some countries provide for specific statutes, terrorism acts. The UK specifically does that. Others come up with criminalizing common offenses but committed with a terrorist purpose. And then we see also in the legislative technique the difference between crimes of endangerment that are basically criminalizing the actus reus is more important, whereas the common criminal offense that's been committed with a terrorist purpose, that's the subjective approach where you have to prove as a prosecutor that somebody was committing killing or preparing commit terrorist offenses with a particular purpose. Broadening of, and then I forget one important thing, sorry, I didn't put it on the slide, but what has been really a breakthrough in Europe, in many civil law systems, so on the continent, is that we've included conspiracy as a crime in our statutes. That has been a controversial offense for a long time, maybe not to you, because, it's basically, this is the system where it comes from, but it has been controversial for a long time because of the fear that it criminalizes mere intent. And the terrorism threat has taken away the controversy over that offense, and we now have it in most of the statutes. Right. Broadening investigative measures. First of all, that can be, that's the effect of broadening or sort of lowering legal constraints, and especially with regard to wiretapping. Normally, you need to have a mandate that is quite high threshold in the sense that you have a reasonable suspicion of an offense being committed or about to be committed. And in the Netherlands, that's been lowered to indications, which is a broader threshold. It's easier to now use this as a power. And in Italy, it's not even necessary to have reasonable suspicion. Here, it's already sufficient that you can show that it's indispensable for prevention of terrorist activity. And here, the interesting thing is also that there is no judicial oversight. Normally, in most civil law systems, there will be like an examining magistrate who will mandate such powers. And in Italy, you actually have a special prosecutor who does that now. And there's been a really outcry amongst criminal lawyers arguing, well, there's no objective judicial oversight, and that goes against criminal law principles. Grid search is something we find in Germany. Germany has not really changed its criminal law to cater to the needs for prosecutorial powers in terrorism prosecutions. And it's really looked more into the intelligence community and how can they broaden powers to that side of law enforcement. And they've introduced, again, what they called Rasterfahndung, grid search, something they used extensively in the 1970s when they were fighting the RAF. And they've dusted it off and are using it at the moment again. There's been a case in the German Constitutional Court where a Muslim student of, I think a chemistry student, that just fit the model, it just fit the profile, the terrorist profile. he argued that he should not have been targeted, and that it was far too general, that the profile, and that goes against his rights to privacy.
Elies, what is the grid search?
Grid search is data mining, where you've got like a terrorist profile and you use a computer program and you look for people who meet certain criteria, that you are Muslim, male, you study chemistry, things like that. Thank you. Yeah, please interrupt me if it's not clear.
No problem.
The RAF is not the Royal Air Force, it's the...
No, it's a Rote Armee-Fraktion. I was hoping that was clear to most of you.
Controversy on the panel
Thank you.
here, the British and...
Thanks. Right. Baden-Meier group is the other word for them. Okay? And that's been used again and extensively. So that's specific for the German response, as it were, to terrorism. The court case, the Bundesgerichtshof, the highest constitutional court in Germany, indeed argued or ruled that this was too generic, the search, and that it should be more specific in the case of this lad, this particular person. In the UK, preventive search and seizure powers have been relied upon, and recently, in fact last week, these powers have been quashed. The European Court of Human Rights have basically ruled that these powers are not sufficiently circumscribed, that there is no adequate legal safeguard. And there was a whole, the Terrorism Act 2000, which provides for such searches. You can search without a reasonable suspicion, and this can be in a certain area that's been designated as a security area, but it was in this case the whole of the Greater London. I mean, this is a big place. And these powers can be used for 28 days, but then can constantly renewed. So it was already for a whole year that constables could do that. The court said, well, there are not sufficient safeguards, despite the fact that you have annual review, and despite the fact that once, before designating such an area, you have to really look at the threats, the terrorism threats, etc. There is some scrutiny there. But it's not sufficient, and they looked at statistic data, how often people were actually stopped, and said it's far too broad, despite these wonderful safeguards on paper. If you look at the practice of it, it is too broad. So that's been quashed, which is quite a controversial ruling. I mean, in the UK, there's an upheaval about it. Expanding pretrial detention is another feature. You find that in most of the systems. In Italy, you don't need to be detained for 5 days. You can be detained without there being a reasonable suspicion of an offense, of a terrorist offense. And during that period, you will not have no access to a lawyer, and you can be interrogated. In the Netherlands, we've lowered the threshold for pretrial detention from reasonable suspicion to from incriminating evidence, which is sort of a higher threshold, to reasonable suspicion. And the UK, there's been a big debate, you probably know, and if not, you know now, that detention without charge, it was for a long time only 14 days that you could detain without charging a person. There was a legislative reform at some point. It was extended to 28 days, and Blair wanted to extend it to 90 days, and he really made an argument in the House of Commons, and he lost it, and that was the first time he actually lost in the House of Commons. It was prominently on TV, prominently broadcast. Brown took it up when he came into power, and he managed to get it to 42 days, but that then was quashed by the House of Lords. So we're still on the 28 days.
You have to be charged with anything in Italy and the Netherlands to be...
No, we've got a different system. It's different in the sense that you do need to have, at least in the Netherlands, a suspicion of an offense. And there is no such thing as a charging then. You have an indictment and you have a suspicion of, an offense that you are indicted with, and then there's no formal moment of charging. And then you move forward from that. Whereas in Italy, that's a special situation where, with regard to terrorism, you can be held without a reasonable suspicion, and without the charging does not come in. there is no moment there. It's really a common law instrument. The controversy over these pretrial detention powers is, why do we detain these people? Is it really because we want to prosecute them? Because this has been a debate in the UK. The argument is we want longer time before we charge them because we need that time to get the information, to get the charge going. But there's also talk of just wanting to detain for the sake of detention and for interrogation purposes, rather than really wanting to go, to prosecute, to go to trial and actually take the case before a judge. And the same has been said about, this is all speculation, about the Dutch pretrial detention powers. Okay, I'll go a little bit faster. Quasi-criminal law measures, this is, especially in the UK, this has been a debate, so-called control orders, where people can be detained not under criminal law, it's like administrative detention. This concerns foreigners who, against whom there's not sufficient evidence to go to trial, but you can't deport them because that would go against, because they might face torture back in their home country, and that would violate the European Convention of Human Rights if you would actually then do that. So these people trapped in the UK, they were detained under the, I have to get it correctly, the Anti-Terrorism Crime and Security Act of 2001, under the so-called control orders. That was then by the House of Lords quashed because it was felt to be discriminatory, these powers, because it did indeed affect foreigners. The law's been changed. We now have the Prevention of Terrorism Act, which sort of reinstates these control orders to house detention. These people have a little bit more freedom. They still have to report every day to the police station, and they can't get on the internet, etc. So there is detention without charge, without really the prospects of a trial. And then we've got the blacklisting, and I'll talk in a minute about that, which is, again, a quasi-criminal measure in the sense that it has punitive effect. And the interesting thing is that both these measures bring the criminal law through the back door. If you violate a control order, if you don't report to the police on time, you commit a criminal offense. The same with the blacklisting. If you participate in an organization which is on a list, you are also committing a criminal offense. Special evidentiary measures, that goes to intelligence, the use of intelligence as evidence. That's possible in the Netherlands. You need to have an examining magistrate who, in sort of ex parte proceedings, on behalf of prosecution and defense, talks to the intelligence officer and comes up with a report, which will then be put before a panel of 3 judges who can then look into it. The defense counsel and prosecution counsel can ask questions via the examining magistrate, and the conviction cannot rely exclusively on such a report. Okay, I'll leave the rest for debate, maybe. The freezing of assets, CADI, that's the important case if we discuss blacklisting within the European Union, at least. The Sanctions Committee of the UN has put Mr. Kadi on the list, and as a result, his assets were frozen, and he had assets in Switzerland, and there was a criminal prosecution against him. At least for 6 years, they investigated his case and eventually did not proceed because of lack of sufficient evidence. But he very much felt that, he took his case to the European Court of Justice. He felt that his right of property was violated and his right to be heard, and he filed the case. The Court of First Instance argued that blacklisting, that could not be, and the regulation, the European regulation implementing that within Europe could not be, that they had no jurisdiction to review it, because UN law is superior to EU law, and on the basis of Article 103 of the UN Charter, such obligations prevail over EC rights and obligations. The European Court of Justice thought about that differently and ruled that there was indeed a violation of Mr. Kadi's rights. And interestingly enough, they said that the regulation, the EC regulation, that had indeed, that was flawed, but that did not affect the UN the Sanctions Committee ruling and the Security Council resolution with the list. So they left that aside. The European arrest warrant, this is an interesting thing, and I found that our American partners are always very much interested in it because it just makes extradition so extremely swift, efficient, and easy. It's been on the table for a long time. It had not been acceptable. Council of Ministers, sort of the executive body of the EU, did not want to accept it until we had 911. And then suddenly, with the threat of terrorism, it was felt that this was a good instrument to implement, and they did it. It's basically a swift extradition procedure. We call it surrender, and it has to be done within 90 days, so very strict time limits. Groundbreaking is the fact that there's no dual criminality verification, and that there's a very limited number of refusal grounds. Now, I've sat as a judge in the extradition chamber, and I've been dealing with a lot of these European arrest warrants, and it's actually quite boring, because what you do is you've got a list where you tick a few boxes, and if the person is sought for an offense which is on that list, you can't really examine any evidence. You just have to trust your partner. It's the thing to do under the EU system, and you just have to recognize it. It's mutual recognition of judicial decisions, and you just go along with it. So that's another measure that can be mentioned when we discuss European approaches to terrorism. The effects, combined effects, I listed a few just on the top of my head, so I might be beside the points or missing a few, I don't know. But to me, it seems as if, first of all, this extension to the criminal law, to the preventive stage, that has the effect of it might erode the presumption of innocence, and especially the burden of proof. And I'll explain, because if you put punishable behavior, if you move that forward chronologically, it's much more difficult to define the line between punishable behavior and daily, ordinary behavior. And it becomes more difficult also to prove what the criminal offense actually is. And with that comes the need for more intrusive investigative measures. And also, and we see that in the UK law particularly, legal presumptions, where if you can't explain why, you are carrying certain possessions that, indicate that you're interested in jihad, if you are also in an area where, close to a mosque where a very extremist preacher preaches, if you can't explain, what you're doing there, and you don't have the intent to commit a terrorist offense, you've got a problem. So, to my mind, it does touch upon the presumption of innocence and the burden of proof. Strengthening state power by lowering thresholds, I think that cannot be denied. Thirdly, limiting judicial oversight, certainly with regard to preventive wiretapping, some of these special procedural measures, judges have less power to really scrutinize, and limiting defense rights. Now, the analogies with the IHL debate, the laws of war, and the debate in the criminal law paradigm are threefold to my mind. First of all, there is an emphasis on the repressive side of law. Law, to my mind, has two sides, repressive and protective. And what you find with regard to these measures, and I also find that in the IHL debate, is that there's a lot of attention for powers to detain, sort of the repressive side of law, at the detriment of the protective side of law, which can be seen, for example, by the weakening of judicial control. And of course, the philosophy behind this seems to be, at least to my mind, a security state-centered approach, which undermines the libertarian approach of the individual who has autonomous rights with regard to the state, who should then provide those rights. To my mind, a balance the balance could be distorted and the integrity of the law could indeed be affected if we don't have an eye for that imbalance that you get when you focus on the repressive side of law. And that can be restored, I very firmly believe, by giving judges a very important role. So judicial oversight should not be underestimated, and especially the highest court, the Constitutional Court, should have the power to scrutinize executive, administrative powers, and should not defer because it is the executive that rules. So with that, I'd like to conclude, and I'd like to thank you very much for your attention.
Thanks very much, Elies, for your survey of these European initiatives. Jamie.
Thank you very much, and good afternoon. I don't know if it's a blessing or a curse to speak at the end, because I know some people might be walking off, trying to catch planes and trains and automobiles. But I think it's also a bit of a blessing, because as much as I had a few key points prepared this morning, having listened to all the other speakers and citations to the Red Cross and to the Geneva Conventions and to IHL and to Law of Armed Conflict and to detention and to DPH and to sacred cows, I wonder whether or not there's anything left to be said. So what I might try and do is actually take it from an IHL perspective. I will talk about the practices of a couple of countries, but maybe we could address that more in the question time. And sort of try and come back to some of the basics when it comes to IHL, because I think one of the recurring themes and I think underlying aspects of the conversations and debates today has been the relevancy of IHL, the adequacy of international humanitarian law, the new types of conflicts, the new types of actors, the new types of weapons, etc. And one sort of message I've been hearing quite often is an all or nothing approach. It's either you take IHL or you leave IHL. There's no halfway house. I would tend to suggest you take IHL. It's not an all. IHL is there. IHL provides a framework. But I would also suggest that there are areas of IHL, given the nature of what this body of law is, that certainly require some more clarity, and we'll talk about the DPH process as well, more clarity and more
What's
detail.
DPH?
DPH is this my famous red book, red and white, Direct Participation in Hostilities.
Okay.
For those of you in the know, you know it's somewhat controversial. For those of you not in the know, I'll try and highlight some of the controversies, and there'll be a few more in the months to come. But let's go back to just some of the basics. International humanitarian law. What are we referring to exactly? I mean, we keep talking about this general body of law in times of armed conflict. We're talking about predominantly 4 Geneva Conventions from the 1940s, 1949, and 3 additional protocols. The 2 of the 1977s, which sort of supplement and complement the Geneva Conventions, as well as the 3rd protocol of 2005, which simply deals with an additional emblem, the red crystal. I have the 2-minute warning here, so I don't know. So you know.
Wrap it up.
Yeah, just in case. I was going to put a 0 at the end of it. So you have the 4 Geneva Conventions and the 2 additional protocols. What do they represent? They represent a balancing act, foremost. And you had Michael speak about the targeting issues in terms of military necessity. We've had a humanitarian approach. And that basically is what IHL is about. They're trying to balance the questions of military necessity, the war objectives, the fulfillment of the mission, the accomplishment of whatever one wants to accomplish in times of armed conflict, but balance it at the same time with questions of humanity, of humanitarian realities in times of armed conflict. And that's why you'll see oftentimes in debates about IHL, there is this sort of clash of cultures. But those in the field, the operators, whether it's military, the humanitarians, as well as the policymakers, understand it's always a matter of finding the right balance. And I can tell you it's going to go on for centuries more. Long after we're gone, you will still have men in uniform telling men with the Red Cross on their lapels saying, well, no, we need to do it this way. We're acting out of self-defense. And we'll say, well, actually, no, it's not really self-defense. You're acting out of something which is a bit more than that. And you can do something less than kill the individual. But those debates will be there. That's the nature of IHL. Unfortunately, that's the nature of armed conflict. You'll always have those situations when there's a debate because you're dealing with people's lives. You're dealing with the people who are victims in the middle of armed conflict, who are caught up, civilians for the most part, persons hors de combat, and you're also dealing with the lives of the military and of the fighting nations. And trying to find the right balance is a fraught exercise and at times a very emotional exercise. But what you have to remember is international humanitarian law was not invented by the International Committee of the Red Cross. Many people refer to IHL and the ICRC as one and the same. International humanitarian law is a result of states sitting down, and the quote from Michael earlier from the diplomatic conference, this is a diplomatic conference involving states. So diplomats from the various states around the world sat around a table, revised the conventions from the early, from the 20th century in 1949 and 1977, and came up with certain standards that they believed to be right, correct standards to apply in times of armed conflict. Not all the solutions were found, and the proof is in the pudding that you eat, that 30 years later, in the 1970s, you had additional sort of revisions and complements to the Geneva Conventions. So a point here, a basic fact, yes, war does evolve. Yes, the realities of conflict do change. But we've seen that for 200, 300, 400 years. That's nothing new in that regard. This whole debate that we have right now about this new enemy, these non-state actors, this is nothing new. Taking the UK example, you look at the Anglo-Boer War at the turn of last century, exactly the same statements were made by the UK SecDef equivalent, saying that we have a new type of enemy. We have civilians who do not stand out from the, we have combatants who do not stand out from the civilians. We have individuals who are blending in with the civilian population. We need to adopt new measures. And we know what happened at the turn of last century. We had the first concentration camps in South Africa, when 22,000 or so individuals lost their lives. That is a debate that was had over 100 years ago. We're still having this debate today. It's a new type of enemy with new types of technology available to both sides, but you still have this question of civilians blending in with combatants and vice versa, and how do you distinguish those? But that's not a new debate, which is why I sort of tend to premise that IHL does address these issues, not in the detail which is necessary, but at least addresses the issues to say you need to try and distinguish. You need to adopt those measures which are necessary to fulfill your military objective, taking into account that not everyone is entitled to fight and not everyone can be subject to targeting. The same goes with weapons. We had a discussion a little bit earlier about weapons and new technologies. Whilst the Geneva Conventions and the protocols don't deal specifically with one type of weapon or another type of weapon, you do have bodies of law out there which address specific weapons, and the Geneva Conventions in the Additional Protocol on Article 36 do place the burden back on states to have some review mechanisms in place, to review the legality of new weapons that aligns with IHL principles. So again, it's states assuming a responsibility and pushing it back towards themselves to review the legality of new weapons. So the debate is ongoing. Does law evolve? Yes. Wars ever changing? Yes, we've seen that since the 1990s. And you've come out from the post-colonial period to the new modern day types of warfare, whether it's this global war on terror or whether it's the type of conflicts you see in the Sudan, in Sierra Leone, in Liberia, where the civilians are caught up in the middle, and it's usually non-state actors fighting one another, and a blending, a mixing, a separation, and a reblending as such. So you have a new type of armed conflict, and how do we address those issues? The conventions don't give all the solutions. The protocols don't give all the solutions. Michael Newton referred to the sacred cow earlier. There's only one sacred cow, I would think, that comes out of IHL, is humanity. There are certain limits. Every war has its limits. That is the sacred cow. How then you sort of take off and peel off the various layers from that sacred cow is a different matter. As long as we understand that, we're on a fairly good starting point. Not such a sacred cow as such, but an underlying rule is the military aspect, the military need, the military purposes, the nature of war, and the objectives. So try and balance those two out. What are the two areas that we are and have been talking about for the most part, which I think the most relevant? One is detention issues, and we've had long discussions about this today, and I think I compliment Michael on your book there. I think you've summarized it quite nicely in terms of the whole debate as to where this whole issue of detention went. And the other is to do with direct participation in hostilities. On detention, the matter is simple. IHL recognizes that individuals in times of armed conflict can be interned for security reasons, imperative threat standards. Likewise, prisoners of war, recognized combatants can be held back from the line of fire until such time as the end of open hostilities. I think the main challenge you have under IHL with regard to detention is that IHL does not line out in great detail the procedures to be followed for civilian internees. You have a lot more on POWs, but when it comes to civilian internees, in particular in times of non-international armed conflicts, you don't have a huge amount of detail. Which is why the ICRC, having worked with a number of governments for the past few years and worked closely with John Bainger's office as well in that regard, kept pushing and saying, okay, IHL doesn't say much, human rights does say a bit more. How do we bring the two together so that the rights of the individuals who are caught up in armed conflict, who might pose a security threat, are properly respected, and that there's a review procedure in place, etc. And that is first, I think, a fundamental question. If we take the argument that IHL recognizes right to intern individuals until the end of open hostilities, but then we take the reality that many are arguing these days that there's no clear-cut end of hostilities, because I'm sorry, when we talk about the conflict in Afghanistan, we talk about withdrawal in 2011. You know, Alexander the Great, the Brits, and so on, it's been quite a while, it's ongoing. When you talk about the other component, the terrorist component and Al-Qaeda, do you see an end in sight? No. So what is the emphasis? The emphasis is on ensuring that the individuals who have been held are being held for the right reasons. So you need the standard, the imperative threat to security. You need the review procedure, ideally twice a year, and so on and so forth. So that individual who no longer poses a threat is and can be released. Because otherwise, indefinite detention becomes a reality, and I think most of us in this room would agree that indefinite, by that I mean forevermore, with no end in sight, would not sort of be in conformity with most laws out there. So the standard, the review procedures that have to be respected. The problem is not many countries have adopted this clear legal framework which includes procedures, reviews, and standards for individuals being interned in times of armed conflict in particular. You have the terrorism legislation, but when we look at specifically armed conflict, that is lacking. We have references to the AUMF. We have references to the Supreme Court, to district court judgments, to much law out there, two already. Okay.
We'll add a bit to the discussion.
Okay. We have quite a lot being formulated by the courts, but I still think there's a bit of a gap, and I speak in my own capacity, not the ICRC, so there's a bit of a gap in this regard, that between the AUMF, for instance, as an example, and what the courts are doing, there should be something more in the middle, some form of legislation, some form of framework which gives the details, standards, procedures, and ensuring that the rights of individuals are protected, so that we know that when someone's picked up, how it's going to proceed. Second element, direct participation in hostilities. And this will be fairly short because it's very contentious. This lovely book came out a few months ago, was to look at this whole concept of how do you deal with civilians who are directly participating in hostilities? How do you make them targetable? What are the standards to be met? Because the key word under IHL is protection. Civilians are protected unless and for such time as they take a direct part in hostilities. Unfortunately, except for some commentary by Jean Pictet and co., there's not much which is being said as to what exactly is meant by DPH. John Bellinger highlighted the fact that experts for about 6 years have grappled with the question. And last year, I think finally the ICRC said, okay, all the experts are not going to come up with some form of consensus, so we need to come up with something at least to give some guidance to individuals out there, especially to the operators, those with the triggers, those who are going to determine whether or not an individual is to be targeted. In what circumstances can someone be subject to direct attack? In other words, when can I take a gun to that individual? That's what the loss of protection means from a DPH perspective. When can that person be subject to lethal force? As much as it's used as detention standard in some courts, that is ultimately what DPH is trying to open. And it's somewhat controversial. Some have argued that it ultimately gives a license to kill because it's given a criteria and putting it on the table saying you can kill this individual in those circumstances, which is not what IHL was really intended for. IHL was more intended saying these are the limits and these are the protections, which is why you have a section on in section 9, when you have time, look up on the ICRC website on sort of the mitigation of suffering. On you might have that license, doesn't mean you have to kill. Ideally, there must be sort of, step back a bit. There might be other means at your disposal. And this comes up with the question of self-defense, comes up with the question of, likewise, targeting of drug dealers. Who is directly participating? And on your question at the very beginning, in terms of what are other countries doing, most other countries in armed conflict situations are fortunate to the extent that they don't have the same situation as the US has, which is Guantanamo. Much of the discussion on unlawful enemy combatant and who can be detained in indefinite detention is linked to the whole Guantanamo issue. If you look at what's happening in Afghanistan and with the ISAF forces, you don't have that question there. They have certain rules, the 96-hour rule, a handover to the Afghan authorities. So you don't have this whole sort of body of detention issues which are out there. You have humanitarian treatment issues, for sure, and Nord for more obligations, but it's less of an issue. And you don't have countries taking out individuals from Iraq and Afghanistan anymore and bringing them back to other territories, Diego Garcia and others, to detain and keep them away from the war front. That's a subtle difference. Canada, we can talk about afterwards if you have a question on that. But I know my 2 minutes up, so I'll leave it at that.
Okay, thanks so much. As the moderator, I get to ask the first question. I cut the discussion a little bit short so that some of our other panelists can participate in this discussion. My first question goes to Michael. Should the lawyers responsible for the torture memos be prosecuted?
Okay, so, yes or no?
Just a yes or no from everybody.
I mean, you have to start out with the proposition that Nuremberg allows lawyers to be prosecuted when they counsel clients to commit crimes against humanity or other grave breaches and violations of international criminal law. So potentially, there could be prosecutions. I think the Obama administration likes to see themselves as Nelson Mandela, and they want, for political reasons, to move forward and not be focused on the past. And especially with the election 2 days ago in Massachusetts, it's really bad politics, I think, to open this can of worms. So they don't want that. What they've done is they've created a special prosecutor to look at probably lowest level perpetrators who either committed acts of torture before the Golden Shield memos were written, or who did things that were even more extreme than what John Yoo had authorized in his memos, which we have to remember include waterboarding, and there were cases where people had been waterboarded over 170 times. But there were things that are even more extreme, and apparently one of the reasons we don't get to see those photos that the Obama administration isn't releasing is because there's some stuff that's really heinous that some really bad apples did. Those people might get prosecuted. I think that the Justice Department is currently looking at an ethics probe for John Yoo, and at the end of the day, if there was some kind of report that really reaffirms what I was saying, and that is that when lawyers in the government see themselves as advocates and don't give neutral legal advice and realistic legal advice to the policymakers, in which they cite both sides of the argument and give them the arguments against so that they know exactly what they're getting into. And when the lawyers purposely cut out all the other lawyers in the government that have an expertise, that this is a problem and that this has to stop. And it would be good, I think, if there was some kind of a report that came out with that. And maybe something like I suggested following the UK rule, which is that someone in L, the legal advisor's office, should always have to be consulted whenever there's an issue involving international law.
Can I interrupt there for a moment? I just want to redirect this for a second to Jamie. Should the legal advisor resign when his or her opinion is ignored or they're cut out of the process?
John, what do you say? I can't answer that.
You don't have a position on that?
I don't take position on that, certainly not. I think
John?
it's something that...
Any
that
insights?
Be a lot few legal advisors. The legal advisor's view is probably ignored on a regular basis. And, you know, the best you can do is to counsel your client as to what the law is, and your advice is sometimes accepted and sometimes it isn't. And then you really have to decide, you know, at what level is it better to stay and fight the next battle and hope that they're going to do better next time, or does there reach a point at which, you know, things are just so awful that you can't stay on, and you know that's something that everybody has to fight with.
And there's a big discussion of that in the book. One of the problems is that when regular policymakers resign, they get to put the reasons for the resignation in the New York Times. The legal advisor has an attorney-client confidentiality, so you can't resign in protest. Basically, people would just think, oh, so you know, you moved on to a better position at Arnold Porter or something. Anyway, and that's the problem. One of the problems why it's not really useful to resign when you're in that position.
Questions from the audience on any of these subjects? Comparative approaches. Yes, please, Cassie.
I have a question specifically directed towards Michael. several of the human rights treaties that the U.S. is a state party to, treaties which were intended to provide substantive legal obligations on the state parties, provide for derogations from such legal obligations in times of national emergency. And considering that immediately following September 11th, that the U.S. did declare itself to be in a time of national emergency, I was wondering if you knew if there's any consideration as a political option of deciding to submit a request for a derogation to the HRC. I mean, obviously, the HRC could not have allowed for torture, but they could have granted permission for prolonged detention without charges or trial. And I know the UK did pursue
Right.
a similar option, though I think there was some limit on that because they had to make sure there was no mistreatment between, or no discrimination between nationals versus non-nationals. But, I mean, was this ever considered as an option? Is it politically viable? Or what, if it wasn't considered at all, is it only because the U.S. was adopting a policy that international law was completely inapplicable at the time? And then maybe towards our international scholars, if they knew if other countries had pursued similar options or if it was politically viable for them, or even if there's any significance to requesting such a derogation.
Okay. No, that's a really great question. Jamie and the ICRC, together with Case Western Reserve, hosted an experts meeting about security detention 2-3 years ago, and about a year ago came out with our report, and there's a good section in there about derogation. As you pointed out, when you derogate, you can't discriminate, and your derogation has to be closely tailored to the exigencies of the situation, and it can't be forever. And so the UK is the only government that has derogated in the war on terror so far. The United States chose not to derogate, and Andre Serena, who was an assistant legal advisor at the time, explained it to the Inter-American Court of Human Rights in saying that the situation in Guantanamo, we, the United States, consider to be extraterritorial, and therefore, as you heard this morning, it is not part of our requirements under the Covenant of Civil and Political Rights. On the other hand, at that time, Andre didn't know about the torture memos. And the waterboarding, and torture does apply by the wording of the treaty to your nationals wherever they commit it. So you don't have that territorial limit for torture, and that's why there was such a debate about whether this was merely cruel, inhuman, and degrading treatment, or whether it crossed the line into torture, because that wasn't just an academic debate. If it crossed the line into torture, then we had an obligation to act even in Guantanamo Bay or Bagram Air Force Base or Abu Ghraib.
I saw some other questions. Yeah, back there.
You mentioned, we've seen today how the U.S. is taking a very strong military approach to the problem of terrorism. And Professor, you talked a lot about the European approach emphasizing the criminal law side. Since there has to be a lot of international cooperation to deal with transnational travel and financing of global terrorism, how do these two approaches mesh? Is there a lot of conflict between the American emphasis on a military or rule of law solution and the European emphasis on criminal law? How do those two approaches interact with one another?
Yeah, that's a good question. Well, the first thing that springs to mind is the possible use of torture evidence. In the case of A Against Others in the UK, the House of Lords ruled that evidence that was provided by US authorities could not be used. And under the common law, that it would not be, you cannot use evidence that, is the result of torture. Interestingly enough, there was a German case where I think, is he the 14th guy, or what is he, the 11th? The guy who was involved in the 9/11 attack, who's been prosecuted in Germany. The German authorities wanted evidence from the U.S. With regard, if there were reports on interrogations by 3 Al-Qaeda members by U.S. authorities, and it was brought to, or it was argued in court that must have been the product of torture and that it could not be used. The German judges wanted to know more about this. So they asked the US authorities, give us some more information about the circumstances in which you got this evidence and who interrogated these people, and the US did not want to cooperate. Eventually, the German judges decided to use it because they said, well, there might be, it has been suggested in reports in the press that there was torture, but it's not proved. So we'll use it anyway. And there is other evidence. So in that respect, you do see this crossover and the problems that it can create. But other than that, I can't think of other examples.
Just to add an interesting twist to that, the international tribunals have been applying this silver platter doctrine, and most recently the Cambodia tribunal decided that it would allow in evidence that the Khmer Rouge had elicited through acts of torture at S-21, which ended up implicating the Khmer Rouge itself. And so they're going to allow that in and then weigh it rather than exclude it altogether under the torture exclusionary rule.
Yes, John.
I mostly have to say that I have to leave a few minutes early, so I want to thank everybody for coming to listen.
Thank you so much for coming.
I do a lot of these, and I'm amazed to see how many students have really stayed through all of this. So thank you. I hope you found it interesting. And to the panel, my many friends on the panel, thank you all very much. Terrific presentation. So you'll see me slip out. I will actually make one comment from my own discussions with Europeans. Is as students I think have heard, much of this debate continues to be polarized, that there's sort of a black and there's a white, and never the twain shall meet. I think most of the students in the room probably seen, well, gee, there really is sort of a melding of the two, of human rights law and international humanitarian law. When I began the dialogue that I began in 2005 with Europeans, in which there really had been no dialogue between 2001 and 2005, truly Europeans were just reading what they read in the newspaper and sort of taking that as what the position was. And as I began the dialogue, and we really were separated, one of the first points was, we in Europe have been fighting terrorism for years. The IRA, the Red Army faction, the Red Brigades, we have not had to resort to this extreme global war on terror where everything is military. We've just used our criminal laws and it's all worked. And that sort of sounded right, but the problem is that think about it. Every one of those people who they were fighting, they found in their territory to begin with, and they were already subject to their criminal laws and to the criminal procedures of those countries. The United States was basically fighting a group that was in Afghanistan and was far away, and except for, frankly, a brief, and I personally think failed, flirtation with trying to treat a few people inside the United States, like Padilla and Hamdi, as enemy combatants, has basically said, if there are people inside the United States, we do treat them consistent with criminal law, i.e. the European model. But if our soldiers are fighting them and they're detained by our soldiers, we can't tell our soldiers that the only reason that you can detain someone is if you actually have an arrest warrant for them. Mm-hmm. Similarly, Europeans are just not faced with that. It's very easy to say, well, we're applying criminal law. If you were to say to Europeans, well, that's fine, but if you have British or French or Italian forces who have been forced to go to Somalia or to Afghanistan to arrest someone who is attacking your country, are you going to tell your soldiers you can only go there armed with an arrest warrant? So I think we're actually finding through dialogue at many of these conferences that we're, at least between the U.S. and Europe and between many other countries, that where we thought we were divided, that we're actually getting much closer. We're not there yet, and I thought what Derek Jenks said is that the answer, it's not because there's a clear legal answer that we have to discover, it's because we're going to have to work together to try to fit pieces of human rights law and international humanitarian law together. So anyway, thank you all very much, and I'm sorry I have to slip out.
Thank you very much for coming.
Just one very brief moment. Mr. Bellinger is going to give final thanks to everyone at the end. Unfortunately, you do need to leave. We're going to be giving a small token of our appreciation to everyone.
Well, thank you very much.
Thanks so much for your presence.
And I'm sorry I feel bad about interrupting things.
We're happy for your final comment. Following off from John Bellinger's last comment for the panelists, we've discussed today the criminal law approach, we've discussed the international law approach, particularly international humanitarian law and international human rights law. What we've heard less of is about an international criminal law approach to terrorism. Does anybody have a comment? We have 3 international criminal law specialists on the panel, so it's a good time to hear what they have to say about this as a potential avenue for addressing non-state threats.
Let's get the ball rolling. I presume you might be better placed than I am. The Special Court for Lebanon, I think, is was a commission set up in 2005, 2006 by the United Nations to look into the murder of the then Prime Minister Hariri and 22 others. And the commission completed its inquiry after about 3 or 4 years and handed everything over to a prosecutor. And the commission was effectively converted into a tribunal, a hybrid-style international tribunal based in The Hague, the special tribunal. Is it special tribunal for Lebanon?
Yeah.
And so far, everyone's looking towards that tribunal because it's the first one looking specifically at the crime of terrorism, derived, I think, in part from also Lebanese law with some sort of international overtones. The difficulty is how they're going to define it. Secondly, I think the main difficulty is getting the cases. And that's where they're stuck at right now. There are 3 or 4 generals who had been held on pre-trial, or let's say not even pre-trial, I mean pre-indictment stage, preventive detention for 2 or 3 years by the court, and they were released last year, I think, by the judges following a request by the head of the defense section. So at this stage, there's no one being indicted. There's no one behind bars. The judges are going, I think, growing a little bit restless. There's nothing going on, and I think the international community is still supporting it, but I don't know how much longer.
Eyal, you had a comment about this, right? Okay.
But just to bring that up to date, the Case Western Reserve has a war crimes research lab that I run that's like the work that Madeline Morris and her students do here at Duke for the detainees. We do it for a variety of international tribunals, and we have an MOU and started doing work for the Lebanon Tribunal. The questions that they've put to us, which aren't private, so I can share them, but I think that they show you sort of the answer to your question, and that they're wrestling with this, and that is, for example, can they apply for terrorism, which is basically a domestic offense in Lebanon, applying domestic Lebanese law, can they apply things like joint criminal enterprise, command responsibility, and the other international criminal law concepts that the war crimes tribunals apply? The other thing is, can they go after people that would ordinarily have head of state immunity? In the Charles Taylor case before the Special Court for Sierra Leone, they decided that court was an international tribunal, even though it was a hybrid court. It was international enough that head of state immunity didn't apply. The Lebanon tribunal is slightly less international, so that's going to be a challenge to them. And finally, they'd like to apply in absentia trials. I think they're going to end up probably trying people in absentia, and they're asking all sorts of questions about, what are the duties of a defense counsel who has to defend somebody who's not present and isn't anywhere near the court. So you're going to start seeing, I think, a lot of interesting new precedent coming out of that tribunal, whether or not they get defendants.
Yeah, but I mean, if I could just tag on to that, I mean, there was, and maybe you know better than I do, the ICTY, in one of the cases, Milosevic, not the Milosevic, but one of the lesser Milosevic's, in the context of an armed conflict situation, acts of terror directed towards the civilian population. So from an IHL perspective, you do have the terrorism component.
Well, I can tag on to that by saying that our Minister of Foreign Affairs, he suggested that the ICC should have jurisdiction over terrorism. And I think he's serious in the sense that he wants to propose this at the ASP, the review conference in April. It's interesting, his colleagues don't think it's a good idea. And I have to say that I agree with the colleagues rather than with the minister. But he's got it in his head, so he's going to propose it. And I think looking at the ICC and how it's functioning at the moment, it's just an extra problem they'll be lumbered with. So
could terrorism be captured under one of the other ICC crimes?
It could, as crime against humanity and maybe some war crimes, yes, and it's been suggested.
What about the potential of the emerging crime of aggression?
Another problem.
How would that link with the 9/11 attacks? If anyone has any insights, comments.
Ooh, Michael.
I'm skeptical whether at this review conference they're going to actually be able to add aggression, because it's come down to a political debate about what the triggering mechanism would be. And the major powers have said the only way we would agree to aggression being in there is if the Security Council has to authorize that. That way, the United States and the other major powers with a veto in the Security Council can make sure that they would never be subject to an indictment for aggression, or any of their colleagues and countries that they protect. And I think at the end of the day that we're probably not going to see aggression added to the court, because it just, that's not acceptable to most of the countries of the world.
And there's going to be successive review conferences after this one, where there'll be new attempts to define aggression. And as terrorism changes, maybe it's going to be also lumped in along with state aggression as one of the potential ICC crimes. Does anyone have any opinion on the panel or in the audience about whether it's a good or a bad idea to try to include terrorists under the rubric of aggressors in international criminal law and hold them individually accountable?
Michael?
Yeah, I mean, I think in the Pan Am 103 case, if you assume that the evidence was sufficient, they ended up proving that Gaddafi in Libya sent agents to blow up an American airline as revenge for the fact that we had dropped bombs on Tripoli in 1986. That's an act of terrorism. It violated the Montreal Sabotage Convention. It's pure terrorism, but it's state terrorism. And it also would be an act of aggression. And one of the nice things, though, is that trial, which we discuss as one of the really creative things that the legal advisor's office helped come up with, that was able to sever a tit-for-tat 20-year cycle of violence between Libya and the United States, because rather than just keep having revenge, they sent these guys to a trial that was all negotiated and in some ways was a bit of a whitewash, because instead of Gaddafi being tried, these two low-level people were tried, and now the United States is happy with Libya and considers it a partner in our war against terror.
Crimes against humanity don't require a nexus with the state. What's gained and what's lost by including the 9/11 attacks under the rubric of crimes against humanity?
Mike and I, too bad Mike snuck out.
It seems that there's some value in reserving particular subject matter of crime against humanity for a certain magnitude of crime that has those elements of widespread scope and systematicity. To me, I think that's enough.
Yeah, but, 3,000 people died on 9/11. That would have been genocide in terms of Srebrenica or some of the places, certainly a crime against humanity under the Yugoslavia Tribunal's jurisprudence.
So the group
So-
targeted would be Americans, you're saying? Because you need the specific intent to target the group as such, right, in genocide?
Yeah, and it was systematic because it was 4 different attacks, and it was, there was numerosity. I think you could have tried that as a crime against humanity. And, you know, if the United States had trouble getting hold of, like, let's say bin Laden had been captured somewhere, wouldn't it have been, and the country wasn't going to surrender him to the United States because of our military commissions, wouldn't it have been interesting if the U.S. and the international community said, all right, well, let's send him to the International Criminal Court?
Right.
If I could just take on, I mean, I actually agree with you to a certain extent, sorry, Michael, but I tend to think that crimes against humanity and genocide are the types of crimes which should be reserved to sort of what Lemkin and others did in '48 in terms of drafting. You're looking more at this kind of specific targeting of a population and the wiping out that particular group for one particular reason. Yeah. As much as I see what you're saying in terms of the numbers and so on, I think prosecution of the 9/11, 5 and others, there's much more appropriate bodies of law and elements of offences that you can apply to them than looking at more sort of massive crime type basis.
There's a Crimes Against Humanity treaty project, and at the Brookings Institution in March, it's going to be announced to the world. Mike Newton and I were asked to do a section of the book, Elies has a different section, about why terrorism should not be considered a separate crime against humanity. Mike, can you just give the bumper sticker summary of that?
I will. But also, I was listening outside. I had a meeting and a phone call, so I was listening. To go back and answer your question, one of the big things that you gain by scoping into the crime against humanity rubric is that plan or policy element, right? The crime against humanity, widespread or systematic, pursuant to or in furtherance of a state or organizational plan or policy. So what you pick up is an al-Qaeda, an organizational philosophy to commit those crimes on a widespread, sustained basis, which in turn gets you out of that little geographic box, right? Because the big debate in the law, humanitarian law context is we're in a conflict in Afghanistan, and there's that, around the jus in bello, you get that geographic constraint, and that's one of the big advantages. The big disadvantages, one is it introduces a huge level of politicization into the international criminal processes, right? So if Prime Minister Verhagen gets his terrorism as part of the ICC, it's disastrous for the ICC. It just derails it. It's really a problem. Problem one. Problem two is that there's plenty of existing law here. You don't need it. Both Protocol 1 and Protocol 2, as a matter of use in bello, already prohibit acts which are intended to foment terror in the civilian population. We've had successful in the AFRC case. The point being, you've got lots of use in bello law, lots of targeting law that already does that. So you don't need to just make a whole new cart. And then the third point was that it introduces a whole level of complexity in the charging, because now you have to decide, I've got a whole new body of crime against humanity law, right, where I run into nullum crimen sine lege problems, and I've got a whole body of use in bello, and now I'm going to be charged with nothing but raw, naked politics in making that choice. And so it comes down to, the only reason you charged me with this was because you had evidence for that. That's right. That's just not justice. And so our sense was that you got plenty of existing law, no point injecting a whole new, after the fact, post hoc legal regime. Maybe we're wrong, but I think we're right.
I'll take one more question for the panelists. Yes, please, in the back.
I guess I feel like the Obama administration is balking on the Guantanamo Bay issue because to re-diasporize all of these incarcerees with all the scrutiny on the ghost claims and the like would necessarily elucidate their incarcerative network. I feel like this need for secrecy brings to light another question. Are people being detained and held indefinitely or definitely without acknowledgement of their possession? Do y'all know of any cases where people are held and acknowledgement of their possession by governments, be they European or American or Middle Eastern, is not present? And if there are cases where people are asking, where are people that we know you have them, and they're being denied, how do those play out? I guess, and I was thinking about the killing of the Iraqi civilians, which the civilian contractors were just acquitted. Randomly, my question is, what function did these civilians who were killed serve in Iraqi society?
Let me start tackling some of that question and let the other panelists as well. First of all, after 9 years of detention, just a couple of weeks ago, the United States finally announced the list of people being held at Bagram Air Force Base in Afghanistan. So that list is now out, but there were 9 years when nobody was sure who was there. The other thing I want to point out, the Public International Law and Policy Group, which is the NGO that I run with Paul Williams and others in the room, just filed an amicus brief in the Supreme Court case of Kayama versus Obama. And just, so you know, I'm an equal opportunity basher of administrations. This is the case about the Uyghurs. And basically, there are 4 Uyghurs who the Obama administration can't find a country willing to take. And they have admitted that these Uyghurs, who are Muslim Chinese, who speak Uzbekistan, very unusual people, that they are not unlawful enemy combatants. They are not in any way a security threat to the United States. They were just at the wrong place at the wrong time, and they are trying really hard to find a place for them, but nobody will take them, and they don't have any prospects. So the district court said we have to let them out into the United States. The Obama administration appealed. They said we don't want the Uyghurs in the United States. The appellate court said as long as the State Department is making a good faith effort to find some country, even if it takes 50 years, which is indefinite detention, that's good enough for us. This is now up before the Supreme Court, and it will be heard in oral argument in about 2 months and decided this spring. And we're arguing, of course, that they need to be released under these circumstances.
Free the Uyghurs as our last remark. Thank you very much for the panelists for coming.
little souvenirs and stuff.
Yeah.
Hey, can I give you the for voucher too? So that we can take
This is actually up to the audience. We could take a 5-minute break and have our concluding remarks, or we could just finish and we'll go into the reception.
think about earlier. Work on issues of lawfare. Does that ever connect with lawfare?
The themes discussed today are central to one of, or the most salient philosophical, legal, and strategic battleground of our times. Together with civil liberties protection, the issues of use of force and adjudication, punishment, and deterrence form the key nexus on which the international community's response to violent extremism and non-state-centered conflict will rest for the 20th century. The questions themselves are not novel. It is sometimes astounding to realize that in less than 2 years, it will have been a decade since September 11th. Ever new and changing responses are debated, responses that sometimes divide the United States, its respective administrations, and the United States and its closest allies and potential adversaries alike. As panelists have noted, the new legal regime that many hope to emerge remains very much unclear. Nonetheless, today's speakers have done much to put into focus and articulate the true issues at play, hopefully setting the stage for, if not resolution, but gradual convergence in law and policy. Still, the possible alternative exists, seriously or ironically, that by the time we've all come to grips with the terrorism issue, terrorism may have been replaced by a new and as yet unknown threat to the international community to face. At the same time, the lessons learned in the current debate will certainly aid us as we confront the next threats on the horizon. On behalf of the Duke Journal of Comparative International Law, I would very much like to thank first our faculty advisors, Ralph Michaels, who is currently on leave at Princeton University, and Curtis Bradley, who was here for part of the sessions, and many of his ideas were also part of the subtext today. Professor Larry Helfer, who recently came from Professor Newton's institution, Vanderbilt, and the Center for International Comparative Law, which both of them head up. I would like to thank our moderators for being present today, Professor Downs from the Department of Political Science, and we very much hope that future symposia will have an interdisciplinary interface as well. Professor Silliman, thank you, and Professor Weisbord. Certainly the panelists, we're all extremely grateful for your presence today. In order, I believe in order, Professor Jinks, and Professor Jinks has a long-standing relationship with the Duke Journal of Comparative International Law, published 2 pieces together with Ryan Goodman, whom we had sought to have present here today. He was not able to be present, writing about how to influence states, state socialization. In other words, what really changes state behavior, in particular in human rights law, but also in other aspects potentially. Professor Morris, certainly grateful for her participation and long-standing efforts in the field. Professor Waxman. Mr. Bellinger, of course, just had to depart. He also has been published in our journal before, particularly 2007, at the opening of the Center for International and Comparative Law, and we hope that he and certainly all of the participants today will continue their long-standing relationship with the journal. Professor Benvenisti, very glad for your presence, and do hope that the opportunity to collaborate again may appear. Professor Newton, thank you. Leila Sadat from Washington University in St. Louis was one of our original invitees. She was very ill during the last part of 2009, was not able to be here, but we are grateful for, at the time, she was going to be part of our comparative presentation. Professor Scharf, certainly very long-standing connection with Duke. He is, of course, a proud alumnus, I believe, 2 degrees, or just the JD?
AB and JD.
AB and JD. Very, very proud of your accomplishments as an alumnus and your long-standing affiliation with the journal. And Professor Van Sliedregt, thank you for being here. And again, we do hope collaboration may continue. And Mr. Williamson, very much the same, very grateful for your presence today. Personally, I would like to thank Drew Crawford and Sheena Paul, our editor-in-chief and managing editor, for their support in this process of organizing, and all of our journal members who have contributed immeasurably, drivers, many, many tasks that they have done, without whose help this symposium could not have taken place. Our publications office here at Duke, Susan Manning, and the Duke staff, technology, who are in the control room as we speak, catering, many other folks that have helped us come together, and certainly the audience. We're very grateful that so many people were able to take time out of their day and be present with us. Thank you very much. We're going to be having a reception downstairs in the lovely Star Commons. So we invite you to all to join us for the reception. Thank you and have a great day.
I could add one last thank you. 11 months, he's been hard at work on almost every single detail involved in today's symposium. Most especially the formulation of today's topic and inviting all our excellent panelists. And today, the journal and the Duke community got to be the beneficiaries of all that excellent work on his part. So thank you, David.